Hi guys, it's Kathy. I hope you're doing well. Sorry I was late. It snowed here. I have to show you. I'm going to show you something later. I'm going to show you a picture later. But we're going to get to the court videos first. Um, this one it's not recent. It was 2 years ago, 3 years ago, but there was like no views on this court at all, even though this was an archive from a couple years ago that I don't think anybody played it yet. So I don't, even though it's a little old, I don't think it's been passed around the internet like some Soviets are. So it's a new subset to us, even though it might not be new. Oh, thank you for the gift memberships. I really appreciate that. I know we didn't hit Bobby again, but Zach, you're going to love this picture I'm going to show later. It is hilarious. Oh my God, guys. Bill's here. Look. Bill, I have to tell you how much I've been thinking about what you said yesterday. And I don't have good news, but I do need to talk to you about it, to give you my 2 cents. So maybe later after the stream, or if it's too late tomorrow. It's no rush. But, okay. We went back in time, Michigan. I don't think this judge is streaming anymore. So if you notice, a lot of the older judges from Michigan just aren't streaming anymore. We miss them. We love them. But I don't know. I don't have my phone with me though, because I ran as fast as I could. Look, I'm not allowed to talk in the beginning of my streams anymore. I'm not allowed to, and I just did. So I just completely ruined this entire stream for my numbers, which really stinks, because the reason why we didn't stream this morning was so that I could use my notifications, and now I just ruined it. I ruined it by talking. So I have to start this video. But I am going to talk later after the court is over, because I have a lot to say, and I know you guys do too. But have to press play. Have to.
9:12.
All right, thank you. Good morning. Calling the case of Shepherd Properties versus Houston, file number 22-2338 LT.
Morning, Your Honor. For the record, Brian Hirschspring on behalf of Shepherd Properties LLC. And I don't know if the court can see, to my right is Charles Shepherd, the representative of Shepherd Properties LLC.
All right, thank you. I have LaShawn Houston and Kimberly Houston listed as defendants. Who's participating by phone?
On and for the record, I'm Houston LaShawn DeYoung, more beneficiary. I'm here in my proper person.
What's your first name?
My first name is LaShawn DeYoung. My surname is Houston.
All right.
I'm here in my proper person, my own right, and having reached the age of majority. I'm a Moore Aboriginal, America's Aboriginal, Illinois national,
Is
but not a
Kimberly
citizen of the United States.
available?
Not a citizen of the United States.
Is Kimberly
Or
available?
the United States for the District of Columbia. Houston Kimberly Denise is deceased. I am the sole beneficiary and real party of interest in this matter.
All right, just a moment. Before the court this morning is the landlord's complaint to recover possession of property, indicating that the person entitled to possession of the property is the plaintiff due to a sheriff's deed of redemption.
I
A
object and
sheriff's
deny.
deed, ma'am, please don't interrupt. I'm reading.
Not a ma'am,
Graph.
excuse me, I'm a male.
Okay,
I object and
sir.
deny.
sir, please don't interrupt. I'm reading from
You're
paragraph.
trying to put something on the record has not been proven.
I'm going to have to
I
mute
object and
you
deny.
if you continue to interrupt the court.
If you mute me, then you are violating my rights. You are destroying my rights if you try
Yes,
to
sir,
mute me.
and I can find you in contempt of court for continuing to interrupt.
You haven't even proven you have jurisdiction over this matter. You haven't proven you have
Judges
personal
don't
jurisdiction
prove
or
things.
subject matter jurisdiction.
Judges don't
Excuse
prove
me?
things. Parties
Don't
prove
prove
things.
things.
That's correct.
No, the court has to prove that it has subject matter jurisdiction and personal jurisdiction over the subject matter.
You are now being
You
muted.
don't have to prove that.
Officer Denham? Thank you. As I was indicating, the complaint to recover possession of property received by the court on October 25th of this year and signed by plaintiff's attorney, who was present on the record, indicates in paragraph 5F that the plaintiff has a right to possession of the property because of a sheriff's deed, and the redemption period expired on September 8th, 2022. Is that correct, counsel?
That is, Judge, and the court will note on the complaint, we actually attached a copy of the sheriff's deed too. I believe it's the next document under the actual complaint.
Yes. So can you give me the history of the tenancy?
Yeah, can I do it informally, Judge, without having my client sworn, or does Your Honor want it to come from my client directly?
Anything that he says is impermissible and it's prejudicial. Statements of counsel in argument or in brief are insufficient for a granting of a summary judgment or dismissal.
Your
He is a
objection
third
is
party in
over.
this matter. He is a third party in this matter. I want my objection on the record.
Your objection
For
is
the
on the
third
record.
time.
Your objection is on the
So
record, and your objection is
anything that
overruled. You're again
anything that
being
someone who
muted.
is a third party.
I need her muted or him muted. Thank you.
Anything that is said,
Counsel,
anything that is said in this meeting is scandalous and prejudicial and a
I am
destruction of my rights.
removing Mr. Houston from the hearing because of continual interjections, interrupting the court's proceedings. I will later consider whether to find him in contempt of court.
Judge, I removed his Chan's ability to unmute himself if you want to.
Thank you. That'll be fine.
Dude,
Yeah.
dude, why didn't you do that like 4 minutes ago? Fail.
He can't unmute himself anymore.
All right. Okay, counsel, what I was asking
Don't worry,
for
I can
is
unmute
basically
myself.
when the tenant took possession and the historical facts as to the sheriff's deed and the redemption period.
Right, Judge. So the way, and I can have my client sworn in to identify for the court the specific
sure.
facts. The actual scenario is the homeowner, which I believe are the Houstons, were residing there, and they had a mortgage. The mortgage fell into to default, and the property was placed for foreclosure, and it went to a sheriff's sale. And my client was a
It
successful.
went into default on the mortgage or on the tax bill?
I'm very upset no one has typed Houston, we have a problem yet. I'm just upset, guys. When jokes write themselves, you let them happen.
On the mortgage, Judge.
Okay, and who held the mortgage?
Genesis it's Genesis Credit Union as reflected in the sheriff's deed.
All right.
And my client, when it was put up for public auction, my client actually was the highest bidder, concluded that transaction through Oakland County, and then the sheriff's deed on the mortgage sale was issued and then ultimately recorded after the 6-month period of time. And the court will note that there's a stamp on it for October the 25th, 2022. I will note for the court that there was an earlier proceeding before your court. I don't know if it was your honor but there was a visiting judge, I believe Judge Gubo.
Yes, Judge Gubo, he's out for a few weeks and will be back next month.
Right. So apparently what happened was because my client is a single member LLC, he initially filed his own proceeding. Judge Gubo refused to proceed on it and
Without
dismissed it.
counsel.
So my client called me and he said, well, I'll have my attorney. He says, nope. So he dismissed it. We refiled all over again. And that's why your honor will note on the summons, we actually have an earlier case number. But in any event, that is how we get here today. So
Okay.
statutory period has already long since expired, and my client wants to take possession now.
All right. Is there any indication that the Houstons participated in any proceedings since default on the mortgage?
Not that I'm aware of, Judge. I can tell you that they didn't show up on the first case. As it relates to this case, you actually ordered that we go first to Oakland mediation and then come over here. They waited the requisite period of time at Oakland mediation. We showed up. Mr. Houston did not show up, and nobody certainly on behalf of his wife, who he says has since passed away. But in any event, nobody showed up there. So we're here today. No, there's been no participation. And the court will note, I mean, you heard a little bit this morning on the record, which is why you muted the defendant. There were some documents filed in this matter by Mr. Houston. And if the court has read them, that's great. But it's pretty much it's the kind of things that he's saying, nobody has jurisdiction over him. You can't take away the property and whatever. Bottom line is he had a mortgage, went into default. We were the successful bidder at the sheriff's sale. 6-month period of redemption has passed. No payments were made, and we want to take possession.
Okay, thank you.
I wish
Now,
I
the
knew
summons that
more
I'm-
about what they're talking about, the 6-month period of redemption. I wish I knew more what that meant, because he had a mortgage. The Houstons had a mortgage. They are Sovsits. The Houstons had a mortgage, and they didn't pay that mortgage. So it went into default, then it went into a sheriff's sale. This guy who has a hat on in court, thank you, Bobby, paid for that mortgage and got that house. Then this guy went to that mortgage company, paid off the mortgage, and the mortgage company sent to Sovsit a letter saying the mortgage had been 100% satisfied. So the Sovsit thinks he owns the house now. Now, he just talked about 6 months. Can't remember what he just said. I just said it too. But redemption period. The 6-month redemption period had passed, and now they want to take possession. What happens during this 6-month redemption period? Does this Sovsit have a chance to pay his back mortgage? And if he does, then what? This guy owns the house, but he can't have it? What does that even mean?
Looking at indicates this case number 22-2338 LT.
Correct, Judge. But if you actually go to, here, it's actually on the complaint itself, the form complaint, under paragraph 1, it asks if there had been prior cases, and we actually listed the other landlord-tenant case.
Oh, yes, thank you.
Yeah, I apologize. Usually I think it's usually on the summonses, but in any, yeah, it's on the complaint itself that shows the earlier case.
Okay, and for the record, that is 22-2133 LT.
Thank you, Josh.
Mr. Houston, I have a question for you, and that is whether within the 6-month redemption period, you did anything to redeem the property. Officer Denham, we need Mr. Houston unmuted.
I've entered onto the record in that first case that that third party was just talking about, proof that that mortgage has been discharged by Genesis Credit Union. And it was discharged before October. It was actually discharged in July.
What do you mean by discharged?
It was discharged. The mortgage is paid in full, discharged. And it was entered into the record of the first case.
I have
Before
several
the redemption period
filings.
was even over.
Did you file
Before
that?
the redemption period was over. I didn't file it over. I filed it in the first case. It's still evidence in that first case that he
Okay,
referenced.
one moment. Attorney Hirschfuss, am I saying it right? Hirschfuss.
I still object to him even speaking in this matter. He's a third party intervener.
He's going to speak. That's my decision.
Everything that he
Please
said
don't
is
interrupt.
scandalous and
Okay, you're muted again.
prejudicial.
Sir, did you obtain a copy of the original file?
No, let me just indicate for the court what the discharge he speaks of.
Yes.
The Genesis discharged the mortgage because we paid it off. They can't keep they can't.
On
keep the
what
mortgage.
date?
If Your Honor will bear with me one moment. He says it was July. 1 second.
He knows he didn't pay for it. He knows he didn't pay his mortgage. He knows this.
Judge, do you mind if I address my client?
Yeah, if you
No
tell him
problem.
to take his hat off.
Oh, here it is. So there is it's, by the way, it's not a discharge, it's called a satisfaction of mortgage.
Yes.
And it's dated on May the 24th, 2022, and recorded in Oakland County Register of Deeds office on June 2nd, 2022. And for the court's information, I will give you the LIBOR and page number.
Yes.
LIBOR is 67821, page number 31. And what's important for the court is that it identifies that on May 24th, 2022, when this is executed, it's a satisfaction of mortgage being fully satisfied. If they don't satisfy the mortgage and remove it, my client would be taking the title to the property subject to a mortgage that he just paid off. So it was his funds, it was the LLC, the plaintiff's funds that went to satisfy the mortgage, and that's why there's the sheriff's deed for March.
Is that reflected on the satisfaction? In other words, you know, what triggered or initiated the satisfaction, or who?
It is not, Judge, and I will tell the court if you follow the line. So the March 8th, 2022 sheriff's sale takes place. A check gets written to satisfy the indebtedness. The next step is that the credit
check written to
it went actually to Genesis,
the mortgagee.
And then everything gets recorded, and particularly the satisfaction, the ordinary course of business gets. If the court wants, I have no problem. So the court has it in its file, following up with the court and sending over a copy, so the court has it. But in any event, this is a, that's what the deed does. So if there had been any redemption or anything like that, the sheriff's department would not record the instrument.
Okay. Mr. Houston, when you made reference to a discharge, do you have that document in front of you
He
where
sure
you could read
does.
it to me?
He's muted. Guys, wait till you see
Officer Denham, we
the
need
next
Mr.
case.
Thank
In
you.
just a second.
the next case. Is so funny. Go touch grass. You should come in because your name is awesome and we have questions. There is no such thing, Eileen. They'll just keep giving them to people.
Just so you can start looking at your schedule, the adjourned date would be January 18th due to the holidays.
Judge, may I ask if January 18th would be the chosen date by the court, are we able to ask the court that there should be some rent paid in the interim? This has been going on since September. And I just think, from a standpoint of propriety, it's, I got somebody living there and something tells me that even on January 18th, I will be having to exercise a court officer, to fully effectuate the orders and judgments coming out of this court. So I would just ask the court also to impose or at least to consider that when we're back on January 18th.
Thank you. I'll take it under advisement.
Thank you, Judge. Your Honor, in the interim, do you want me to email over to the court a copy of the Genesis satisfaction of mortgage?
Yes,
Is there an email that goes from them? They would know what comes to you?
yes.
Eileen, you got
Here,
D's
you
nuts
have
for
that.
you too.
The email address for LT. All right. I'm just going to give you mine
Thanks, Judge.
by chat.
Okay, thank you, Judge. Would you want also a proof of service followed up in the court file or not necessary?
Yes, please.
Okay,
I'm not able to chat you directly at this point. I'll see if Officer Denham can arrange that.
thank you, Judge.
Josh, you got Bobby. You're the king. You got Bobby.
Hey,
T,
Judge,
thank you
on
so
the
much for
18th
the
at what time?
memberships. Josh, thank you so much for the
That would
memberships.
be-
Are you ready, Judge?
Memberships. And again for the memberships. Eileen, thank you for
Oh, the
50
time
memberships.
would be in the afternoon,
Thank
but
you,
the actual time would be set by the clerks on a notice.
Right, live or by Zoom again?
By Zoom.
Okay,
All right. I have not yet adjourned it to continue, sir, but go ahead. You were going to read the discharge?
It says satisfaction of mortgage. Know all men and by these presents that
Zach.
Genesis Credit Union
Thank you.
of Auburn
Thank you,
Hills does
Zach.
hereby certify that a certain mortgage dated May 3rd, 2018, made and executed by LaShawn Leon Houston and Kimberly B. Houston, husband and wife, to Genesis Credit Union and recorded in the Register of Deeds office for the County of Oakland, Michigan, the lot and everything, the tax parcel and all that, is fully paid, satisfied, and hereby discharged as of today's date, 5/24/2022.
Thank you. And that is the same document that the attorney for the owner has read into the record, sir. And so he's indicated that it's his client Mr. Or Shepherd Properties LLC, who satisfied that mortgage by paying it off. In what
Judge,
amount, sir?
a
In
deed
what
or
amount,
bond.
Mr.?
Judge,
A deed or bond found with the debtor is presumed to be paid. He has no mortgage with his name on it. He has no proof that he's an adverse party or that he's a bona fide party to this matter. He has no proof that he gave any consideration to the sheriff, and the sheriff gave any consideration to me in order to sell my private property in the first place, which is actually owned by a trust, and the Oakland County Register of Deeds and the Oakland County Treasurer has been notice of that property has been transferred into trust as of 2021. So at what point in time did the sheriff give consideration to me or my trust for my property in order to sell it in the first place?
Sir, you would have to consult an attorney about that process.
I don't need to
However,
speak to an attorney. I'm here my own proper person in my own right. I'm suing you this. I don't need no attorney. He's no guardian over me. I'm not a minor.
all right, thank you.
Now, furthermore,
You're going to be
Genesis
muted
Credit Union
now
has-
in order for me to address
Can I
some
have your
of what
name?
you,
Can I have your name, please?
my name should be on the screen, or you're on the phone.
I
It's-
don't have the screen open. I'm on a telephone. Can I have your name, please?
Yes, when I'm ready
The
to
name
give it
can't
to
speak.
you. When I'm ready to give it to you. Please mute Mr. Houston so that I can address his issues. All right, Mr. Hirschus. What I heard read into the record by Mr. Houston was the same document that you read into the record, a satisfaction. And so at this point, the question becomes evidence of ownership. Now, Mr. Houston did not indicate that he had any documentation or proof that he is the individual that satisfied the judgment. What does your client have? You
So,
indicated earlier that you attached to the complaint a sheriff's deed on mortgage sale. It reads, this indenture made March 8th, 2022 between Roger A. St. Jean or St. John, a deputy sheriff in and for Oakland County, Michigan, party of the first part, and Shepherd Properties LLC, 17, and this is an address, 17118 Adrian Road, Southfield, Michigan, 48075. Party of the second part, hereinafter called the grantee. And so those are the parties to that mortgage sale. Is that correct?
that is, Judge, and if I might,
And your client is Shepherd Properties LLC.
right, and its sole member is sitting to my right, and I introduced him a little earlier, to your honor. You can see him now in the
Yes.
picture, yeah.
Yes, and further witnesseth that whereas LaShawn Houston and Kimberly D. Houston, husband and wife, made a certain mortgage to Genesis Credit Union at 2100 Executive Hills Boulevard, Department 1, Auburn Hills, Michigan, 48326, hereinafter called the mortgagee, which was duly recorded in the office of the Oakland County Register of Deeds on June 5th, 2018, and LIBOR 51871 on page 78, where said mortgage contained a power of sale which has become operative by reason of a default in the condition of said mortgage, and whereas no suit or proceeding at law or in equity have been instituted to recover the debt secured by said mortgage or any party thereof, and whereas by virtue of said power of sale and pursuant to the statute of the state of Michigan, in such case made and provided, a notice was duly published and copy thereof was duly posted in a conspicuous place upon the premises described in said mortgage, that the said premises or some party of them would be sold on the 8th day of March, 2022, inside the Oakland County Circuit Courthouse in Pontiac, Michigan. So that satisfies me that at the sheriff's sale, the landlord who stands before us today as the party entitled to possession, did take ownership of the property. I believe that addresses the crux of Mr. Houston's argument that he, rather than the current landlord and owner, is entitled to possession. What were you saying, Mr. Hirschus?
I just wanted to identify for the court if, so, and you correctly read the date of the sheriff's deed being March 8th, 2022. So the ownership takes place at the time they got the deed. The second thing, and it takes time for them to process everything. The second document you'll see then is this discharge, which is really called the satisfaction of mortgage, which gets recorded in May. So that's secondary. So first we get ownership, and then they finally satisfy the mortgage with the money that we paid. And the court will note smack in the middle of the document, and then it's again stated at the bottom that they actually received it, $63,401.10. And the court will note, again, somebody took a couple of bucks off, but that's what they received from my client. And it was actually a $4,000 overbid. But that all gets processed, and that's why it takes.
The amount that I'm showing is $63,470.95.
Correct.
Okay.
All right. And then what they do is, as I say, it gets taken care of with Genesis, and then Genesis ordinary course of business took them about 2 months to record the satisfaction, so that when my client took the deed, he's now not subject to the very mortgage that he just paid off.
Right. All right. So we will adjourn this until, or continue it on January 18th, 2023 in the afternoon. The docket time will be stated on the notice of hearing that is mailed to the parties and counsel.
Very good, Judge.
And the reason for the continuance is for the plaintiff to present the satisfaction and the recorded deed.
He's not done yet, guys. Don't worry.
Any questions?
The court wants the plaintiff to submit it to the court?
Yes.
All right, so just so the court notes, the actual sheriff's deed is attached to the complaint.
That's the recorded copy?
That's the recorded copy.
All right.
And the court will note up at the top is the actual stamp from the Register of Deeds office with the library and page number.
All right.
And I would note for the court that one of the things the defendant, Mr. Houston, said was that in that earlier case that he filed some document in. That was this case.
Well, he called it a discharge, but
right.
He read the satisfaction.
It's actually, in case the court wants to see it, he actually filed a copy of it with some document called Notice of Subrogation and Substitution. But having said that, the 1, 2, 3, 4, the 5th page in is that document, the satisfaction of mortgage. I point that out so that the court notes it actually has those documents before it.
All right. Well, then we'll have 2 copies.
Okay. When would the court want that?
Officer Denham?
Yes, Judge.
Am I able to chat the attorney directly, the email address to send documents?
Yes, just select his name in the chat.
I'm not able to. I only have everyone and you as my options.
Hold on one second. I think that's me. Okay, try now.
Yes, I can do it now. Thank you. All right, the Pontiac, Michigan is not there because I'm a visiting judge. And Mr. Houston, my name is Judge Sheila Miller Martin.
She gave her name finally.
All right, we can unmute Mr. Houston before closing for today.
Could you repeat that, please? Repeat that, please. You said Sheila Miller Martin.
That's correct.
Have you taken an oath to uphold the Constitution, Judge?
Sir, I don't answer those types of questions. I'm not a
Have you
witness
taken
or a
an
party.
oath? Have you taken an oath? That is a question for you, Judge. All you
Goodbye.
have to do is say you've taken an oath.
Oh man. Okay, look, we're going to another video right away, but I have to show you this picture first because it's freaking hilarious. Okay, to remind you guys, I live in Pennsylvania. We get lots of snow. It's normal. Feet of snow is normal for us. We're fine with 2 feet of snow, 3 feet of snow. Business as normal. 3 feet of snow. It's okay. We clear our roads. We salt our roads. We're fine. We were supposed to get 1 to 3 inches today. This is 3, not this. That's 2. And we got this winter weather advisory. right? 1 to 3 inches. And they start telling us what to do. Before the snow arrives, prepare an emergency kit. Okay? Make sure you have all this stuff, right? Warm blankets, batteries, flashlights, food, and at the bottom, insulate your home. We were supposed to have 1 to 3 inches. That's not even snow. And we get all these safety tips. The roads are going to be slippery. No, they're not. It's 2 inches. Come on. We live in Pennsylvania. We should not have to deal with that. I did see a spin out on the road today, though, driving when on my way home, and I had to get off the highway quick because it was right in front of me, which took me on a detour that made me late because people don't know how to drive in the snow. Anyway, this next one I just think it's pretty funny. It's Kentucky. We're going to Kentucky for a while.
Commonwealth versus Shirley Canester. Next.
No, have her sit down. She's got some health issues.
Are you Shirley Canester? Good morning. This is 25 CR 0074. Were you born in 1950?
Yeah,
Last 4 digits, Social Security number 5060.
yeah.
What does the Commonwealth have here?
Well, there's two issues, I think, Your Honor. Both, Mr. Cross filed a motion to suppress, which we're ready to proceed on. He's also filed a motion to release the identity of the transactional informant that was the basis of the search warrant. In the police report, Ms. Canancer, when she was being processed at the jail, basically accused a lady of being that informant and says she's gonna get it. So that we've got case law that basically says when an informant's been threatened and they're a reliable informant, the Commonwealth doesn't have to release their name. And that's our position at this time.
Her response, Your Honor, is that, of course, Ms. Knatzer made some sort of passing statement, which I don't think could be viewed as a direct threat, but
Unless it was about you or me.
I can understand the Commonwealth's position. I just don't agree with it. However, the problem we have is A, this is a transactional witness. B, this case can't be tried unless we have that individual's name. C, we can't have an effective hearing regarding the search warrant because credibility and the subsequent investigation after the report is received are the two major issues. You know, did the officer was he proceeding in good faith based on a reasonable foundation that he had to obtain the search warrant? Now,
We frequently have hearings where they say that it was a reliable person if they've previously had information from them before, that's without revealing.
well, possibly, we don't know what we're going to
I
get
know
into.
it's possible.
It's possible, but if it's somebody somebody's just a snitch out there, that's great. We don't know. We have an idea of who this is. Now, here's the other thing. There's probably some sensitivity to things like this, and if we have a hearing on this, it might be good to do it off camera and
What's the
perhaps,
sensitivity?
well, when you start talking about people who report people for possession or sale of drugs or
That's why
whatever.
Mr. Stockton doesn't want to reveal it.
Well, especially when Mr. Natcher names a name that she don't want to get. I mean, that's not giving her a Christmas gift.
Well, is that who it is? I mean,
Well, I'm not gonna confirm or deny that, but she gave the name, so, and she said she's gonna get it.
The only thing that would have changed with the threat would be the name.
Yeah.
Your Honor, I want to take this up.
When you were gonna be ready to have this suppression hearing?
Well, you got the witness here today, the officer.
Well, let's see what develops. We'll have the suppression hearing, see what develops. When do you want that? Let's do it now.
That's.
Yes, ma'am.
Here we go.
Let's roll her over.
Buckle up for this lawyer, guys.
You will call your witness, Mr. Stockton? You want to come up here?
I don't know if I can watch this again. I don't know if I can.
Will you raise your right hand? You swear the testimony that gives the truth, whole truth, nothing but the truth.
Yes, sir.
Okay, state your name.
Thomas Pendergrass.
You got to speak up right now. I mean, who you employed with in what capacity?
As of now, I'm employed with the Pickett County Sheriff's Office in Tennessee as a deputy sheriff.
Excuse me, Judge, I'm trying to do three things at once. Not doing any of it very well right now.
You want to pass this to the end of the docket? So
No, let me get my thoughts.
The judge is in a hurry. The judge needs this to go
Officer
fast.
Pendergrass, where are you employed now?
The Pickett County Sheriff's Office, Tennessee.
In Tennessee, back in July of 2025, where were you employed?
The Clinton County Sheriff's Office here in Kentucky.
Were you one of the officers involved in the search of the home of Shirley Canascus?
Yes, sir.
Without naming any names, tell the court how that search developed. And
The initial search developed from a search warrant that we were able to obtain.
you need to speak up.
Sorry, sir. The initial search derived from a search warrant that we were able to obtain.
did you have anything to do with obtaining the search warrant?
Yes, sir, I was present.
All right, did the information that was in the search warrant flow from an arrest that you all had made that prior to the search?
Yes.
Without naming the individual, what was the nature of the arrest?
It was a traffic stop with the arrest for the driver for DUI and possession of methamphetamine.
All right, and what did you learn from that defendant that led you to get a search?
I had learned from that defendant that they had just previously to the traffic stop, purchased the methamphetamine at the residence of Shirley Can Answer.
I mean, did she, the person telling you this give an address?
Yes, they did.
Did that person provide you with any further information as to drug purchases that he or she had made at that address in the past?
Not in the past, sir. Just the events of that night.
Was the sheriff present when that arrest was made?
The sheriff was not present.
No, not at that time.
No, sir.
The judge is in a hurry. He's looking up at the sky. He's like, don't kill this lawyer.
Who prepared the affidavit for the search warrant?
I can't recall if it was Michael Raines or his assistant, Angela.
Were you the officer that swore to the search warrant?
Yes, sir.
Yes, sir.
You look, I've got the approach, Your Honor. Look at this document and tell me what you believe that to be. And I think that is, yeah.
I don't think the lawyer can retire yet because he's probably still in this trial right here trying to ask the next question.
If that is, believe be part of the affidavit, the search warrant.
All right, and that was, and you are the applicant and that you were the one. Would you read that to the court?
Not in your head will not get it. That's a voice activated microphone.
Yes, sir.
Just read what the affidavit that you filed with the district court asking for a search.
This says, acting on the information received, affiant conducted the following independent investigation. Through investigation, the affiant learned from the arrestee that she had just previously left the residence of 656 Cat and Mouse Road, Albany, Kentucky, 42602. The arrestee stated that while at the residence, she snorted a line of dope and took 2 hits off of a meth pipe. The arrestee stated that the substance she used was given to her by the residents of 656 Cat and Mouse Road, Albany, Kentucky, 42602. The arrestee further stated that this residence is a place she frequently goes to get drugs.
Now, were you present when the officers actually went to Mrs. Canaster's house?
Yes, sir.
And conducted the actual search? Who else was there? What other officers?
Deputy Christian Markham with the Clinton County Sheriff's Office, Officer Parker Hickman with the Albany Police Department, as well as Trooper Brandon Poole with the Kentucky State Police, and myself.
So they're mad because they won't give up the name of the snitch, even though she knows who it is. She knows exactly who it is, but they're mad that they won't give up the name of the snitch.
Did you hear Mrs. Canaster make any statements during or at the conclusion of the search?
Yes, they were.
Did she make any statements about who she thought the informant was that turned her in?
Yes.
What did she say about that individual?
Can I refer to my citation?
Yes, sir.
Says during casual conversation at the PD, which would be the police department, Canancer stated that she thought Diane Smith had turned her in and stated that she was going to get it.
But Diane Smith actually was not the informant. Is that correct? Without telling who was.
Correct.
So at that time, Ms. Canester made it a threat. It showed that she was going to get the informant, whoever she thought it was.
Check, Your Honor, that's leading and that's not what was said.
Well, I sustain the objection to the.
Well, Judge, it's the position of the Commonwealth that we do not have to give
Let's
the,
just finish the question.
I'm through with him, I'm through with this gentleman.
That's the prosecutor.
Deputy Pendergrass, I do have some questions for you, sir.
Yes, sir.
So this individual that was subject to the traffic stop, was this an individual you were familiar with?
Yes, it was.
Okay. And what had been your the basis of your familiarity with that individual?
Prior arrests.
Okay. Is that the only dealings you had with that individual?
Yes, sir.
Did the prior arrest deal with anything regarding honesty or veracity, or were they simply drug or DUI?
Judge, I don't even understand the question. I object to
Well,
that.
I'll rephrase it. Do you recall what the nature of the previous arrests were, sir?
I can't exactly recall.
Were they drug related or do you know?
I can't recall.
Okay. Now, specifically, the information that you received was that there was methamphetamine at that residence. And in fact, when you conducted the search, no methamphetamine was found. Is that correct?
That's correct.
And do you know what the ultimate disposition of the case was involving the informant? You know, if she pled guilty or was convicted?
The informant, that was not my case.
Okay.
I think if-
Okay. Okay. Who was involved in that traffic stop with you?
Myself and Officer Parker Hickman from the Albany Police Department, as well as Trooper Brandon Poole was present toward the end of the stop.
Where did that traffic stop occur?
It occurred at the intersection of Allen Street and it was at the end of Allen Street. I cannot recall the other road that
Okay.
intersected it.
One end of Allen or the other. Allen Street be about 2 miles from this
Yes.
Location where Miss Canatra lives. Is that correct?
Approximately 2 miles.
So it would not be in the immediate vicinity, correct?
That's correct.
And you did not see
2
this
miles.
vehicle, observe this vehicle leave from the residence of Miss Canatra. Is that correct?
That is correct.
Okay. And you had no other information other than what this informant told you that this vehicle had been to the Canatra residence. Is that correct?
I believe that is correct. Yes.
Okay. Now, your affidavit states that you received information to traffic stop. First of all, the traffic stop, you had a search and found a plastic bag of white powder substance. The substance field tested positive for methamphetamine. That's correct, right?
That's correct.
Okay. Now, below that in your affidavit, it says acting on the information received. Now, I'm not understanding how this information, what information was received by you before we get into this so-called independent investigation.
Can I refer to my
Yes, you may, sir.
Right here, on this page.
Yes, sir, I have it. That's what I have pulled up. But I'm not wanting to get into the second part. I'm wanting to get into the part above that. What information was received other than you found meth on this informant?
That they had previously left the residence of 656
But
Cat.
that says,
Well, I didn't finish his answer.
I'm sorry, please finish your answer.
Sir. And that arrestee, while it was at the residence, used methamphetamine. That was the information that we were
Okay,
talking.
so what you're stating to this court is that that was the so-called following independent investigation, correct?
Be correct?
Okay. But it's what happened, and I'm trying to figure this out. You stopped this individual and found meth, correct?
I did not stop the individual.
Okay, so you were with some people that did.
Yes, sir.
Methamphetamine was found, correct?
That's correct.
At that point in time, there was information either volunteered or responded to by questioning that I got this meth at 656 Cat and Mouse Road or Shirley Canatras, whatever. Is that correct?
That's correct.
Okay. Now, after you received that information, what independent investigation did you do?
We acted on that information.
Okay, so am I correct? And there was no independent investigation by you, or as far as you know, by any of these officers after this defendant, after this informant told you this information, correct?
There was questioning to the informant for validity,
But that's all at the time.
Let him answer his question.
that substances would be there. We then took that information to the county attorney, then a search warrant was.
But what I'm asking is, after you got this information from her that said she'd been to a house 2 miles, what other independent investigation was conducted, if any?
That is all.
Okay. And the only dealings that you had with this individual before is prior arrests, correct?
Correct.
Would that affect your determination as to the credibility of an informant if you'd arrested them before?
No, sir. I believe that they were telling me the truth at the time.
You believe they were telling you the truth, but no methamphetamine was found, was it?
That's correct.
Okay. I have no further questions.
Actually, according to your affidavit that you read just a moment ago, the arrestee in that instance said that she snorted a line of dope and took 2 hits of meth. Is that correct?
That's correct.
Right. Now, was the address that the arrestee gave you the address of Mrs. Conklin?
Yes, sir.
And you all went, after you went to, where did you get the search warrant?
The county attorney's office.
Let me ask a question here. How long did the person you arrested say it had been since they had been to this residence that y'all had been searched?
Sir, we were told that it was directly previous to the stop.
How long after you got the search warrant did it take you to go to the address that was given?
Approximately 30 minutes.
Same
From
night?
the signing, yes, sir. The signing of the search warrant.
And exactly what did your return show that you found there that night?
Can I refer to mine?
Yeah,
There's approximately $9,058 in cash that was in multiple denominations and bags and some bills laying loose.
where was that located?
This was all, this part was all found in a safe, in a bedroom to the left of the house. It was, believed to be Shirley Canancer's bedroom. Also, she stated to us, that was her bedroom.
When you say she stated that it was her.
Miss Canancer, Shirley Canancer.
Is
stated
the
to
lady
us.
sitting here?
Yes, sir.
What else, if anything, what else was found?
There was 51 dosage units of a white oblong pill with the inscription M523, was in a clear plastic bag. That came back to be oxys, 10 milligrams. There was 50 dosage units of a yellow round pill with the inscription 230. It was in a clear plastic bag. That was also oxy, 10 milligrams. There were 6 clear bags containing suspected marijuana that had a total approximate amount of 25.65 grams. There was also 9 pill bottles containing different types of legend drugs. The majority of it was tizanidine.
To find anything else related to drug activity?
Not in that room, sir. That was all.
The return I'm looking at, Mr. Cross. Do you have the return or a copy of the return in your records?
I don't think so, sir.
Do you know who prepared the return?
That was me. That was
All right. So when I ask you if there's anything else other than the pills that you described, okay. Did you find any drug paraphernalia?
There were, various pops.
Sure, that he's someone that really detailed.
You're picking up on the microphone.
I was trying to tell you I'm here
You're picking up on the.
and I messed everything up.
Okay, you have anything else?
Now, Deputy Pendergrass, the return says, quote, various drug paraphernalia, close quote. Did you itemize or particularize what you said were pipes found?
There were just multiple pops that were collected. That was all.
And when you say pipes, what kind of pipes do you mean, sir?
Pipes used to smoke substances.
Were these in the safe? Were these found in the safe?
No, that was not in the safe.
Okay. You know who was living at the Canancer residence?
Shirley Canancer, Tawny Canancer was there. There was also a juvenile, male. And also they had said that, I believe it was a grandson, was also staying there, but he was not present.
You guys got me a text message from Josh saying I forgot to unmute, and I didn't. I only had one hand. I got the text, Kelly. It's there. It said I forgot to unmute, but I didn't. I had to get the trial back on. I only have one hand, which is more ribs than you have right now, Josh.
The time for the search warrant.
Now, the safe was locked, correct?
Yes, sir.
Okay. Now, let's go back to the initial traffic stop regarding the informant. The informant didn't say 656 Cat and Mouse Road, did they?
That's correct.
What did they say? What did they refer to?
Shirley Canancer's house.
Okay. And did they specifically refer to Shirley Canancer or just say Shirley Canancer's house?
They said Shirley Canancer's house, and when I further questioned them about where, they said it was on Cat and Mouse Road. They were able to describe the house and which side of the road it was on.
Now, when you and the other officers obtained this information, did you all have a discussion amongst yourselves how next to proceed?
Yes, sir.
Okay.
It was a mutual.
But what was the nature and substance of that conversation, sir?
Well, I can't exactly recall. It's been almost
Now,
a
Officer
year.
Pendergrass, you're not a native of Clinton County, are you?
No, sir.
And I believe you live in Tennessee now, correct?
Still live in Kentucky.
Okay, okay. How long have you lived in Clinton?
Approximately 5 years.
Okay, but you didn't have any experience with this informant other than being involved in arrests prior to this night. Is that correct?
That's correct.
Did you discuss with Hickman, Poole, Markham, any of the other fellows of their prior experience or dealings with this informant?
I can't exactly recall if I did or not.
So based on what you can recall today, no one in that group indicated they had previous, no one, rephrase that. No one had any basis for believing that this individual was reliable based on any prior dealings with it. Is that correct?
I can't recall the conversations that we had.
So you can't remember anybody saying, oh, I believe her, she's told me stuff before or anything like that. No conversation regarding that.
I can't recall, and I
Okay.
wouldn't want to say I did, and it's been so long, I
If
can't
you don't
recall the
remember it,
conversations
you
that
just
we
don't,
had.
you know, you can't recall.
It wasn't
Thank you.
citation.
That's all I have.
In the conversations that you had following the arrest on a traffic violation, Mr. Cross asked you about conversations that you might have had with Sheriff Markham and who is it, Officer Hickman?
Sheriff Markham wasn't involved.
Who else was there?
Well, I know who was there. You know, there's a state trooper, city police officer.
Officer Poole.
What you would have bet Sheriff Markham retired like 30 years ago. This lawyer just doesn't remember.
Did anybody indicate to you that they recognize that address to be in a high drug traffic area?
Yes, sir, we all knew that was a high drug trafficking area.
So there was some investigation made other than just relying on what the individual told you.
Yes. Just prior knowledge, of knowing of that area.
That it was a high traffic
Yes.
area.
Yes, sir.
Great.
But the affidavit says you conducted, quote, following independent investigation, close quote. And you just simply had some knowledge, some reports from somewhere that there may have been some drugs at the Canatch residence, correct?
Yes.
Okay. You didn't conduct any subsequent investigation.
That's
correct?
already been asked and answered multiple times.
I understand.
Okay. Thank you very much. You want to make your argument, Mr.
Your Honor, I'm through with Deputy Pendergrass. I do want to address the court regarding the name of the
I'm
informant.
not going to give you the name.
Your Honor, I understand that at this point in time, but I wanted to address the court and move to do something. I would
Your
move,
motion.
yeah,
You got it.
I would-
You
I would-
deserved it.
yeah, I would move that the name be furnished to the court in camera and divulged to counsel for the defendant so I can make my own investigation of this individual and the prior criminal charges that they've had in order to help gauge and determine the reliability. The basis of this is we've heard that he's had prior dealings with her, but nobody had any informants. I just want to see what kind of record this gal's got, if it's a female. And I think that's appropriate. It's a safe way to do it.
Okay, Mr. Hunley, you want to make your argument on the validity of the search warrant?
As I understand the privilege law in Kentucky, which starts out that at the initial stages, they definitely is a privilege. The Commonwealth does not have to reveal the name.
I've already ruled on that. Okay.
I
I want
was-
to know about the validity of this search here. I want your ultimate argument. If you give the argument.
Well, I think the search judge is valid. You've heard the proof.
Tell me why you think it is.
Well, there's no reason to suspect that informant was telling anything but the truth that night.
Well, let me
That she,
let me do a Socratic method here. Okay. Well, you got something?
No, I just, no.
Okay, let me, so what we have here is we have a stop of someone who is arrested.
That's correct.
They're charged. Upon interrogation of the individual, they say that in an approximate time, they've been to the defendant's house and used drugs there and bought drugs.
That's correct.
Okay. Now, and so they come get a search warrant, they go there and they find drugs there.
That's correct.
And then she makes a statement. She thinks she knows who it is, which would indicate to me that maybe there'd been another transaction
That's possible,
going
Your
on there.
Honor.
That's possible. And then they search and they find drug paraphernalia and they find drugs, multiple units of various drugs and that's what. Now, tell me why that search is valid, or is that enough? Do they have to do any other prior independent investigation or reliability?
Well, you'll have to ask the most important thing, I think, Your Honor, is that all the officers there that night, when the girl gave them the address, recognized that to be a high traffic drug area. And,
Okay, now with that additional information, is that enough to sustain the search?
I think it very well could be.
Well, I know I'm going to decide what it could be. I want to know what the Commonwealth believes it is.
I don't see why it wouldn't be.
I want you to tell me, and you think the case law in Kentucky allows the search under the circumstances that were just related by you and something that.
Well, the case law is all over the place on these things, Judge. Depending on which case you would pick out. But
Well, here's the thing.
Wait,
You're going to have to tell me.
Judge, what do you mean the case law? There's way too many laws for me to look at, Judge. I can't find a law for this. Listen, in my day, the prosecutor told you what it was, Judge, and you went along with it. I don't know why you're telling me to look up laws. Do you know how many laws they added in the last 10 years?
Tell me what you're relying on.
you want us to break the case?
I'm going to ask Mr. Cross, you've heard what the Commonwealth had to say, and I don't believe it's necessary for you to respond to this juncture. And let's have the case brief, and we all agree on what the facts were. I stated the facts and you supplemented with something that was crucial. So we will have briefs on the thing.
30 days, okay, Your Honor?
30 days is fine.
Thank you.
This officer be excused, you may be excused. Okay, thank you.
Okay, so in 30 days, which is a
We'll
drop
schedule this case to come
in the
back
bucket for him.
on February the 12th.
Oh.
February the 12th. Billy Davis Jr.
Oh boy. Okay. Let's go to, this one is a little choppy. Okay, it's going to appear to be choppy because this was this next one was a interpreter case. I hate when I forget a common word, but it's an interpreter case, and I deleted all the interpretation, so we only hear the English parts. I missed a few. It's fine. I missed a couple. It's fine. It's just it went too slow. Maria, oh my God, hi Maria. It went too slow for me, and I can watch slow all day long. I just watched that lawyer. Oh my gosh, I was giggling so much when he made those long pauses the first time I saw that. Anyway, no pauses in this one. Not with this judge. No way. This judge, for now, might be exclusive to this channel. But I suspect, maybe, you might be able to see this judge on Law Nerds Unite. Oh, I got it out the first try, Zach. Woo! It's a tongue twister for me. I suspect, I don't know though, that Law Nerds Unite might start playing more Colorado courts. Yeah, like Eric Johnson, maybe. Or Susan Blanco. Maybe. Anyway, but for right now, it's just here. And you're going to love this judge.
The court will call numbers 1 and 2 on its docket, 25 CR 150 and 25 CR 3948, both People versus Brian Ariola.
Sam Romano for the people.
Jessica Crandall on behalf of Mr. Ariola, who is present in person in custody.
Good morning, Mr. Ariola.
Buenos días, señora Arriola.
Mr. Ariola is here today for sentencing in both cases. The court has received and reviewed the pre-sentence investigation report. Are there any changes or corrections to the pre-sentence report?
Yes, Your Honor, I do have a couple.
Bien.
I'm first just making sure, I'm sorry, Your Honor, I was looking at this when the case was called. I believe that the range on the second case may be enhanced based on conviction in the first case, even of a misdemeanor.
The date of offense on 3948 was July 13th, 2025. And I believe that was while he was on bond in 25 CR 150. Do you agree with that, Ms. Crandall?
I agree with that. I don't believe he's enhanced since he was convicted of a misdemeanor in the original case. And either way, I think we've, at least as far as today's sentencing, stipulated to a cap on any Department of Corrections time. I understand it could become relevant if there's a probation sentence and a later revocation. But my position pursuant to Colorado Revised Statute 18.1.3401 subsection 9 is that since he was convicted of a misdemeanor in the original case, he is not subject to an enhanced sentencing range in the second case.
Mr. Romano, that's also my recollection. Do you have any authority for your position?
Judge, I'm looking at subsection 9, B, which states that at the time of the commission of the felony, the defendant was on bond for having pled guilty. Oh, I'm sorry, Your Honor, that's inapplicable. Then my mistake. I'll retract what I was saying.
For purposes of the record, the court does not find that Mr. Ariola is enhanced for sentencing in this matter. Any additional corrections?
Yes, Your Honor.
Sí, su señoría.
Page 3 of the PSI under 25 CR 150. It says there that the protection order was modified to allow for electronic contact on August 11th, 2025. I'll just note for the record that that's incorrect. The protection order was modified for electronic contact on July 7th, 2025.
Thank you.
No further additions or corrections, Your Honor.
Ms. Crandall, any corrections?
Señorita Crandall, ¿algo que corregir?
Only as it pertains to pre-sentence confinement credit. So in 25 CR 150, I have 161 days of pre-sentence confinement credit, and the PSI only notes 2 days. That's based on the court
Revoking his bond.
revoking his bond on August 11th and him remaining in custody since that time.
Okay. Mr. Romano, on behalf of the people.
Your Honor, I'll first just note that the victim is present but does not want to be heard. She did want me to provide the court with her translated victim impact statement.
Does Ms. Crandall have a copy of it?
She does. And I would also really
La
just
señora
direct,
Crandall tiene
I'm sorry, go
copia
ahead.
de esto, sí, también le daría la palabra a la juez.
And I would really just direct the court to the first page. The remainder really relates to restitution.
Right. The court has reviewed the statements from Ms. Leah Lara.
Your Honor, so the people are requesting 4 years in the Department of Corrections on 25 CR 3948. And we are requesting 364 days in the county jail in 25 CR 150, understanding that that's stipulated to run concurrent. I'll say this, Your Honor.
Before he says anything, that's crazy. What we just heard is crazy. This is domestic violence. The state is asking for 4 years. That's crazy. We never see that. We see probation. with a no contact order or a piece of paper. You know, go ahead out in probation. Here's a piece of paper that says you better not go back and hurt her, because there's a piece of paper right here. He wants 4 years. And this guy does not have a long history of domestic violence or anything.
I think that today my request for sentencing is going to be relatively lower energy than it otherwise should be because I'm recovering from stomach flu from earlier this week. But I'd ask the court, or I'd just note that that does not represent the extreme aggravation and seriousness of this offense. In fact, my opinion is that few people charged with these offenses are as deserving of a Department of Corrections sentence as Mr. Areola. The initial case, 25 CR 150, that's the misdemeanor plea. That was a strangulation and menacing, if I recall correctly. That in and of itself was a serious case, and that was the case that I inherited when I started in this courtroom. Without getting the court too involved in negotiations, the initial offer on that case, the offer that I believe PH was either waived for, that was initially extended, was a stipulation to probation. The parties were still negotiating when we appeared in court and modified the protection order to allow for electronic contact between Mr. Areola and the victim. Less than a week after we modified that protection order, Mr. Areola picked up this new offense, 25 CR 3948. I can't emphasize enough the domestic violence dynamics that were present during that second assault and the seriousness of that offense. Mr. Areola appeared or came to pick up Miss Laura with roses in hand, ostensibly to get back into her good graces. He would later beat her with those same roses, Your Honor.
Y él después la golpearía con esas mismas rosas, su señoría.
During an assault in his vehicle, Mr. Areola choked Miss Laura. He beat Miss Laura.
Él golpeó a la señorita Lara.
And she was eventually forced to jump from a moving car just to get away from him. That not being enough, he then attempted to drag her by her hair back into the car. And the only reason that the assault stopped was because Good Samaritans and onlookers were able to stop it from continuing. I can't imagine the fear that Miss Laura felt in that moment. And I don't believe that probation is an appropriate sentence given that conduct. Beyond that, Your Honor, Mr. Areola has shown little to no remorse, as borne out by the PSI. He says the charges aren't fair. He makes himself out to be the victim rather than Miss Laura. And frankly, Your Honor, he can't even admit that he has a substance abuse problem, despite probation noting that it was at play in both instances. This is an extremely aggravated case and an extreme violation, frankly, of the court's orders. Mr. Areola has already benefited from the plea bargain in that he is only pleading to one felony, and that felony is capped at 4 years. Any additional decrease to the possible sentence, I think, would be unjust to the community and to the victim. And I do frankly think that Mr. Areola continues to pose a threat to the victim, in that if he was released today, I would worry that he might even go so far as to kill Miss Laura. For those reasons, Your Honor, I am requesting, as I started with, the 4 years in the Department of Corrections with any misdemeanor county jail time to run concurrent.
Okay, guys. Now it's her turn. Okay? Now the defense attorney is going to speak. This is her job. She's doing her job, and she's doing the best that she can, and she does really well, because I get really mad at her. Really mad. But that's why she's there. She's there to do her job. So, let's...
Ms. Crandall, on behalf of Mr. Areola.
Judge, I would just start by saying I don't think it's fair to say that Mr. Areola has taken no accountability and refuses to acknowledge that Ms. Lyra Lara is a victim. Mr. Areola has agreed that he caused psychological and physical harm to Ms. Lyra Lara. He is regretful of his actions, and he does apologize and take accountability for them. While he has been in custody, he has been attending anger management courses. The pre-sentence investigative report also recommends outpatient treatment for him. It indicates that he has mental health needs which require treatment, as well as substance use needs which require treatment. We are asking the court to consider a probationary sentence for Mr. Areola. Per statute, some of the purposes of sentencing are to allow for both rehabilitation and proportional treatment of people in similar circumstances.
En
Mr.
situaciones parecidas.
I'm sorry, Mr. Areola has 0 criminal history.
El señor Arreola no tiene antecedentes penales.
He has never been convicted of any crime, not even a traffic crime. As a result of taking accountability for his actions in these cases, he walks away with both a misdemeanor and a felony conviction. He also walks away with 2 domestic violence convictions on his record. These are things that may lead to harsher penalties to him if he were to ever be charged in any type of.
This is the defense. It's hard on him if he gets convicted of this. It'll be very hard on him. Judge, if he gets convicted of this, you don't understand. It's going to be really hard on him.
Case in the future. These are consequences that will stay with him for the rest of his life. Mr. Areola, as a result of his actions and taking accountability for those actions, will have difficulty finding work in the future. He will suffer, as will his children and mother who depend on him financially. He may also have difficulty finding places to live. And these are consequences that are resulting from the convictions in these cases.
Y estas son consecuencias como resultado de las condenas en estos casos.
Domestic violence treatment is specifically created and designed to address needs of substance use and abuse. It is designed to treat past trauma and to ensure that individuals do not continue to repeat cycles that are unhealthy that they have learned in the past. The pre-sentence investigative report has reflected that Mr. Areola has experienced at least some level of trauma in the past. I don't mention that to excuse his behavior.
Yo no lo menciono para hacer una excusa por su conducta.
But the effects of trauma are physical, lasting, and real. And Mr. Areola, I do believe, is someone who will and can engage with treatment. I think the domestic violence treatment programs are designed specifically for someone like him, who has never previously had an opportunity to unpack what he has experienced in the past and to change his harmful behaviors. And I know based on my conversations with him that he has a sincere desire to learn, to change, and to do better in the future. Mr. Areola has spent about 6 months in the jail. This has been punishment to him.
Este ha sido un castigo para él.
It has led to loss of a job that he was proud of and had been advancing at. It has led to a loss of other forms of stability that he had in his life. I do think, particularly given how overcrowded Colorado's prisons currently are, that a prison sentence for Mr. Areola will cause further difficulty mental health-wise to him. And I do not have faith that the Colorado Department of Corrections will provide him with adequate treatment to actually address any needs he may have and prevent future similar behavior. Certainly, the court would have the option to sentence him to the Department of Corrections if it gave him a chance on probation and he did not comply with the court's orders. But we would ask the court to give him a chance at probation so that he can actually engage with treatment and actually change some of the patterns and heal from past trauma.
Judge Jack Mudry, interpreter 22070, taking over from my colleague Victoria.
Thank you, Mr. Mudry.
You're welcome, Judge.
Mr. Areola, you don't have to make a statement.
Before he makes a statement, I got to tell you, this new interpreter comes on, right? And I was pretty much clipping out equal sections. So they would talk and I would cut out almost an equal section. and they were talking almost an equal section. Now this guy comes on, and they would talk, and I don't know if he was just like adding a whole bunch of more words, or I don't know if he was just talking slower, but his sections are huge compared to Victoria.
But if you'd like to tell me anything before I impose sentence in this matter, now is an opportunity for you to do so.
Sí, buenos días.
Yes, good morning.
Good morning.
Primero que
Buenos
nada,
días.
quiero pedirle perdón a Laura, mi expareja. Siento mucho lo que pasó.
I'm very sorry about what happened. I want to apologize to Laura, my ex-partner. I'm very sorry from the bottom of my heart about what happened. It should not have happened, and I apologize for it. I'm responsible for my actions, and I've never said or claimed that I was the victim. I'm responsible for my actions, and all I want to do is ask you to give me the chance to show that I'm a good citizen.
Fue lo correcto, que actué mal.
I've had 6 months to reflect on this. I've been detained and in jail, and been able to reflect on this, and I know that my behavior was not right. If you will give me the chance to be on probation, I'm willing to take classes, and I'm willing to take responsibility towards society for what I did and do the therapy that I need to have.
Es todo lo que puedo decir.
That's all I have to say.
All right. Mr. Arreola, thank you for your comments, and I appreciate you taking responsibility before this court today. The court has considered the facts of both cases and the arguments of counsel. The court has also considered the factors enumerated in Colorado Revised Statutes 18-1-102.5. Mr. Arreola brutally attacked Ms. Lira-Lara after seeking a modification of the protection order that was issued for an offense where he strangled her. What's most striking to the court is that the assault was so severe that she jumped out of a moving vehicle. You followed her out of the vehicle and continued your assault. This happened in broad daylight in the middle of the road. Bystanders had to intervene in order to stop you. Mr. Arreola, that behavior demonstrates to the court that you were totally out of control that day. The time you had spent in custody and my previous orders did not stop you. In this case, the court does feel a Department of Correction sentence is the only appropriate sentence based on your conduct. In all honesty, the court finds that the cap is rather low considering the nature of harm here, and you could have faced far more severe consequences. In 25 CR 150, the court's imposing a sentence of 364 days in the county jail. The court authorizes pre-sentence confinement credit of 161 days. In 25 CR 3948, as to the count of second-degree assault, strangulation, the court imposes a sentence of 4 years in the Department of Corrections. That sentence will be followed by a 3-year period of mandatory parole. Court authorizes pre-sentence confinement credit of 195 days. All cases and counts are concurrent to each other.
So that means the jail time doesn't even count. It's just going to get eaten by the Department of Corrections time, by the prison time, 4 years.
With respect to restitution.
Judge,
and you think it's over. But no, this judge has more.
we did file one restitution cover sheet with supporting documentation. That was for $3,590.59. That stems from 25 CR 150. It was filed early on in that case and relates to, I believe, a cell phone and other damage to the property of Miss Lara. Since the beginning of that case and then through 25 CR 3948, we've been in good contact with Miss Lara. And she has in turn been working with crime victim compensation on it seems like thousands of dollars of medical bills that stemmed from these two cases. While we're hopeful that crime victim compensation will cover any additional.
I know it's very tiny, but he's very upset right now, and his lawyer is trying to comfort him.
Out-of-pocket damages related to those medical expenses. We are asking for the 63 days to file a final restitution amount, just in case. I'd assert that the people have shown due diligence in trying to get a final restitution figure. However, we're working within a complicated system of medical bills and crime victim compensation. And my specific concern is that my understanding, and while I'm not entirely familiar, but is that sometimes crime victim compensation has caps to how much they can pay out of pocket.
So it's okay. Now, before the judge speaks, from what she's about to get into here, I firmly believe that Judge Bland was a prosecutor. Nope. Was a defender before she became a judge. Though I don't know. But you tell me, try to guess. Did she used to be a prosecutor or a defender, or none of the above? She just was born and was a judge.
Just to clarify, my understanding is there is a request for restitution in 25 CR 150, and that is the complete amount that you're requesting, correct?
I think.
Are you just requesting ongoing time for the case involving the second assault?
That's incorrect, Judge. There were medical bills related to the first offense, is my understanding. I think some for physical harm, and then there's also therapy bills, and I'm not sure exactly how much those are at this time. So I'm asking for the 63 days to finalize restitution in both cases, just to make sure that there's nothing that couldn't be covered by crime victim compensation.
Sounds okay.
Why couldn't that be done by today? The date of offense for the first case is December 8th, 2024. He pled guilty in November. We're 3 months after that. What will change in the next 63 days?
Judge, I understand the court's concern.
She doesn't like 63 days for restitution. That's why I think she was a public defender.
I'll note a couple of things I think are relevant to your question. First off, the initial sentencing date was actually set a week from now, I believe, on January 23rd. I also, as I mentioned in the beginning of my sentencing argument, have been essentially out of work for the last week. My understanding is that the victim has been working diligently with crime victim compensation and providing bills to them as she can, but that it's been an ongoing process. I do think it's appropriate for the court to set that, if the court were to grant the 63 days, to set, given the time that this has been pending, to set it at that 63 days and not grant any further continuances or extensions of the restitution deadline. But I would just assert that us asking for this additional time is for us to do our due diligence and to ensure that Mr. Ariel is not paying for expenses that could be covered otherwise necessarily. I would also note, Your Honor, that during the pendency of 25 CR 150, the case that Your Honor cited as obviously being the older one that's been pending for quite some time, I would say our focus shifted pretty significantly to the new law violation once it occurred, and revoking bond and making sure that the victim was safe.
Now remember, when the defense attorney starts to speak, he was remorseful. He was very sorry about what he did to her. He should have not have done any of that.
Ms. Crandall.
Senora Crandall.
Judge, we'd object to the court granting additional time for the prosecution to provide information. We'd ask the court to enter a restitution order today. I echo the court's concerns when it comes to timing. The original case has been pending for over a year. The second case has been pending for about 6 months. Mr. Romano, for the record, did not object when I made the request to move the sentencing 1 week earlier. And I think if Mr. Romano sincerely believed that 1 week would have allowed him to finalize restitution and that would have made a difference for our sentencing, he could have expressed that when I requested to change the date. I understand concerns of being ill, but we're talking about having had 6 months to a year to get information. There's no requirement that the prosecution wait until a plea enter to seek restitution information. And even if they had, as the court noted here, they've had nearly 3 months to finalize that information. The legislature and the courts in Colorado have made clear that the expectation is that these matters are finalized prior to orders of conviction entering. Ms. Lyra Lara has been present at every single court date that Mr. Areola has had. The prosecution has had ongoing conversations with her. And frankly, Mr. Areola should not be caught by surprise by these types of requests and conversations. Mr. Romano has indicated that they've received bills, documentation, and have had ongoing conversations with Ms. Lyra Lara. None of that information has been provided to the defense. The defense has never been made aware of those ongoing conversations. And so given how long these cases have been pending and the lack of information supporting the request for additional time, we're asking the court to enter orders today based on the information that has been provided to date.
All right, in 25 CR 150, the court's going to enter a restitution order in the amount of $3,590.59. The court finds that's for pecuniary losses suffered by Ms. Lyra Lara as a result of Mr. Areola's conduct. I decline the people's invitation to give additional time in that case. So that'll be the final restitution order in that case. I am going to grant the people's request and issue an order that Mr. Areola is required to pay restitution in 25 CR 3948. But that specific amount of restitution is to be determined within 63 days following today. While the court does understand that many matters proceed to immediate sentencing and that makes the job difficult for the people with regard to restitution, in this instance, we did have a pre-sentence investigation report. Despite that, given the people have indicated that Ms. Lyra Lara's expenses have been ongoing, the court does find it appropriate to give them that statutory timeframe. If any additional or if any restitution is requested in 25 CR 3948, the defense will have 14 days to file an objection. In light of the restitution order in the 150 case, the court will waive waivable fees and costs in both cases. At this time, the court will remand Mr. Areola to begin his sentence in the Department of Corrections. Thank you.
Yes.
Judge, I would request to set a restitution hearing now and issue a writ to the Department of Corrections for Mr. Areola to appear in the event that a restitution request is made.
That's denied. I don't have a restitution request. Thank you.
Gracias.
Ryan Hall for the people.
Mr. Castle, for Ms. Pinkham, on behalf of Mr. Knoll, Judge, the court needs to advise Mr. Knoll of the protection order. At this time, he is not willing to sign it. I think that does relate to the reason that case is going to 1H. That being said, the statute does not require that he sign it because it's not a case involving unlawful sexual contact, stalking, or domestic violence. And so as long as the court advises him on the record, that is just sufficient.
Okay, Mr. Knoll, why won't you sign the protection order?
I have never committed a crime in Colorado.
Okay.
There's no one to protect.
Okay. At this time, the court on its own motion is going to raise the issue of competency. Mr. Knoll, I'm going to set your next hearing in courtroom 1H. Well, they can make a determination as to whether or not you're.
All right, I need to know. You guys have watched my channel for a while. Who is in 1H? Who is he going to see next? Any idea? Any idea? Any idea?
Competent to proceed. The court will stay or enter the mental health stay in this matter. Mr. Knoll, I understand that you do not want to sign the protection order. However, I will advise you that you shall refrain from contacting directly or indirectly communicating with any victims or witnesses. You shall not possess, purchase, or control a firearm or any other weapon. You cannot have any ammunition. You can't consume any alcoholic beverages. You can't take, transfer, or I don't know why box 8 is checked. I don't necessarily think that's applicable here. And I will indicate on the record that I have advised you as to the protection order boxes 3, 4, and 5, and 7. I'm going to direct the people to uncheck box number 8 based on the charges that Mr. Knoll faces. I don't think box 8 is appropriate.
Understood.
If you can give me a new copy, I will sign it and include it as part of the record indicating that I've advised Mr. Knoll. And then, Mr. Knoll, you're going to go to courtroom 1H on what date? January 20th at 1:30. You're going to go downstairs. Mr. Castle's going to write that down for you.
May I speak? I've never had a victim in Colorado.
Okay, I understand. Some of it didn't make sense, so that's why I changed it, but you're gonna have to address these larger issues of your competency with Judge Arnold.
I've also filed 2 pieces of paperwork, the petition.
He's going to see Judge Arnold, but he's really going to Judge Susan Blanco at the end of the day. He's going to be right in front of Judge Blanco, and she's going to talk very slow and sweet to him, and he's going to tell her how he's never had a victim in Colorado.
The judge to end my requirement to register forever with 2 different agencies.
Okay, you know what?
public
You're
defender.
gonna talk to Judge Arnold's about that when you go to court on January 20th, okay?
So that's
All right.
income, that's your public defender, and that's the date that you need to be there.
And I would like to
Kelly,
say
you
the
got it.
reason I'm there is because their own laws, their own paperwork says that after 10 years, I have the right to file the paperwork to end
You
it.
do have the right to petition to deregister. I'm not telling you you do not, okay? But I want you to know that you have to go to courtroom 1H on January 20th. That's all the business we're gonna do today, is that I'm telling you your next court date, okay?
Is that at 8:30 or 1:30, Judge?
1:30.
So I'm gonna write.
I have been declared incompetent by a judge, so I struggle, but I'm just trying to tell you the facts and I'm trying to follow the law.
Thank you, Mr. Knoll. All right, once you get that form from Mr. Castle, you're free to go.
1H, okay? Next Tuesday, 1H downstairs, and Ms. Pinkham can answer any of your questions.
Thanks, and I'm sorry it's so hard to talk to me.
No, it's okay. You're doing.
Have a good day, Mr. Knoll.
Yeah, sorry.
Eileen, you have seen her before. I'm going to show her quick right now, but this is not the next clip. I have one more clip, and it's Judge Jacobs. Yeah. But real quick, before we get to Judge Jacobs, I'm just going to show you Judge Arnold. And then you'll say, oh, yeah, I remember her. Hold on, I'm looking for her. Yeah, this one right here. Yeah, I'm going to play her for a second, see of her voice. I think I need to go backwards a little bit.
I think we've already addressed count 1 because in custody you're not yet a prelim, right? When do you want me to set this over for?
February 18th, please.
February 18th. This matter will be set at 9 o'clock in the morning for disposition. Anything further?
See? Perfect. Perfect disposition, perfect voice for mental health court. That's Judge Blanco. She gets all the competency issues, people. Okay, now listen, we are not about to go to a calming voice. Not at all. We're about to go to Judge Jacobs. He's in Indiana. Zach might play him, but nobody else does that I know of. I've never seen him, and I already know he's not anywhere. And I'll tell you how I know. I'll show you if I can. Here's Judge Jacobs. I'm very professional. If you look in the top right-hand corner, maybe there's how many users are watching. Oh, it's not there, this one. Sometimes they show you how many users are watching the live stream, and it's usually always just me. There might be 2, and the second one is the court itself, watching itself. But no, it's not in this one. But that's how I know no one else plays this judge, because no one else ever is on.
Good luck to you, sir.
Thank you. Hey, Your Honor. Your Honor.
You soon, okay, Mr. Lloyd?
Hey, I just got a quick question before you leave. How can I show up down there? How can I show up in person down there when I don't have no ride, no nothing?
There's 2.5 months to figure that part out too. I don't know how you're gonna get it. If you got a job, you can get a bus ticket or something, or work toward a bus ticket. Sometimes a city or county trustee will give you a bus ticket to where you need to go. I don't know.
What do you mean if you get a job? Quit being mean. Why does he have to work?
Public Defender's Office, Mr. Lewis, we can talk about all that, okay?
Okay.
Thank you, Judge.
Thank you, sir.
Do I call you today?
Yeah, call today.
Call this afternoon at 4.
Okay. Thank you.
Thank you, sir. Back to Ms. Spalding, 2205 F2012, Mr. White.
You know, he's gonna do an open admission basically and agree to the proposed sentence. The thing I would, now, if you're wanting her to do 90 actual days, it actually wouldn't be 180 days being revoked because she pled above the level set.
I'm gonna do 180 anyway. We'll just, if it's less, it's less. All right, so Ms. Spalding, we've talked about the waivers and you understand all that. Has anyone forced, threatened, or coerced you or offered you anything of value to get you to admit to the violation today? Raise your right hand. You solemnly swear or affirm under the penalty of perjury the testimony about the gives truth.
Yes.
Thank you. Now, Mr. White's a factual basis, please.
Shelby, I want to take it back to August 2nd, 2023. On that date, you actually pled guilty to dealing in methamphetamine, correct?
Yes.
You were sentenced to 6 years on community corrections, is that correct?
Yes.
Okay, and part of your term with community corrections was that you take random urine drug screens and not consume any alcohol or illegal drugs without a prescription, correct?
Right.
And you admit that on 2 occasions you tested positive for THC and admit that you used marijuana on those 2 occasions.
Yes.
And you admit that that's a violation of your community corrections.
Yes.
No further questions, Judge.
All right, Ms. Spalding, do you admit by behaving as described by your counsel, you violated the terms and conditions of your placement with community correction?
Yes.
You did violate the terms and conditions of placement. Your admission was freely and voluntarily given. There's a factual basis to accept it. I'm going to revoke 6 months of the previously ordered placement with community correction order that served in the Clark County Jail. I understand that won't be the 90 days that I was.
Be 135.
Okay. Okay, I see. 135 actual days. You'll be taken into custody today. When you're released, you still owe community correction. What 3 is? Hers is 6, right? Well, minus the time she did.
Yeah.
Okay, so make sure you check in with community correction the day you're released. And then you'll resume that. And I think there was some probation after. Is that right? Or was it all community correction? Okay. All right, that is it for today. Thank you, ma'am.
Your Honor, we would also request that in the sentencing order that it be noted that she do that time in the Clark County Jail.
I don't think she is eligible for placement. Yes. So we'll put that specifically in the abstract or the order that she's serving in the Clark County Jail. Okay. That works. Thank you. You're welcome.
Your Honor, to have a seat.
Yes, please. We'll call for an officer. Thank you very much. Amanda White, come on down, please.
Thank you.
And Ms. White is 10C02 2212 F61569. All right, and so I'm not used to you guys being in person,
No.
which is
And we
fine.
came in with a broken knee of all times I have to come in person. I
Ow.
can wait on it now, though. That's okay.
So we recalled the warrant, sent you to community correction in October. What exactly are we doing today?
Well, this was actually, I think, going to be the hearing. You basically had told her at this date, I think, I will just say, we would acknowledge probation violation. There were drug tests, that's it. What she would like to do is go back to finish her time on community corrections. Community corrections is not necessarily down with that unless she would go to a sober living house. And I don't even know at this point in time, they're even still willing to do that. And you basically said, hey, you got 6 weeks from the last time we were here, get that done. Or she very well was going to go to jail today. So she has unfortunately not actually got actual confirmation of going to sober living house, but like I think a lot of talk that she has an appointment tonight, an interview tonight.
At 6 for an Oxford house.
and they said that I could move in right away. I could be in an Oxford house tonight. And then I also talked to Bliss House, and they said that, she wanted to talk to my community corrections officer first to make sure that it was gonna be okay with them, that I stay at the Bliss House. But she wouldn't have a problem with, helping me either. But I could be in an Oxford house tonight with no issues.
Well, then why
At
weren't you
6
in Oxford
o'clock.
House last night then? Because this has been pending, like we talked about. It's been pending for a long time. Why did you wait until today to?
Well, I wanted to stay home with my kids on Christmas for real. And then, it was very difficult to find somewhere with an open bed.
Okay.
And I do
I've
want
been
to say, I
calling-
guess I want to kind of back up a little bit too, because she did go to a sober living house in North Vernon. That was in North Vernon, though. That's not somewhere
Right.
community corrections could do, and I'm not sure that that house really gave them any indication of what she did, how well she did. I know they did notify community corrections that she left, but that's all they did. They didn't tell her if she left against medical advice, because she completed or anything like that. So I wanted to say she didn't not willy-nilly do anything. She went to inpatient at Centerstone in English for the 30 days, then went to the sober living house, which I think is also, is it called Centerstone?
For 60 days.
For 60 days. So hopefully that helps a little bit, but she did do something. Community corrections really wants that to be in an area where they can monitor her. So I asked her to go look, obviously Clark, Jefferson, Harrison, those counties. And so I don't know. I know this has been pending.
Yeah.
I don't know if we can admit and just say she has till the end of this week to get in there. And if not, she just needs to report to jail.
Yeah, I'm not sure I even want to go that far. Ms. McCray, state's already said, I've got no states requested jail time, so they're gonna want jail time on this. Who from community correction wants to weigh in on what I should do if Ms. White admits today? Erica's got a camera on, so let's presume that's Erica.
Yeah, so I mean, this has been going on over years. She's had all that time to find a sober living place. She did supposedly complete that one, which I was going to work with, but since she never got into a sober living, then she probably just needs to serve out.
Okay. All right, thank you, ma'am.
Which one are you talking about on that, Erica? I know that there was one that she ended up not being able to afford because there was a garnishment in her wages that we got that taken care of. So I know that it sounds like we keep making up a bunch of excuses, but that one looked like literally that garnishment came out and she couldn't afford to pay what they were going to require to pay. So, but like I said, we took that care of that garnishment.
Yeah.
So she'll be able to keep her job. Okay.
So if we were to, let's say, she's got sober living tonight. You said you can get in tonight.
6 o'clock.
If I order you into, can you all work with whatever Oxford House? We don't know which one it is yet. Can she wear the bracelet at the Oxford House? Okay.
Ginsburg.
Yes, you want at either place or the Bliss House, but I will say that the Bliss House is a little difficult to work with as far as the bracelet goes, because their program is very strict. It clashes.
That must have been why they said they wanted to talk to you.
But then we're also talking about states asking for serve it out. So let me see what it.
I mean, I agree with Erica. I'm not going to step on my case manager's toes. I agree with my staff. If that's what her recommendation is, that's what my recommendation is going to be.
I'm looking through everything, the history of the case and violations here and there and everything else we've got. So while I'm thinking, Ms. White, let me remind you, today we're here. You have the right to a contested hearing. At that hearing, you can cross-examine all the state's witnesses and evidence. If you were to be found in violation of the terms of your community correction placement, you would have a right to appeal that finding, and any sanction that were to come from that finding. For that entire process, you have the right to a public defender representing you free of charge. And if you decide that you want to admit to the violations today, you would be giving up each and every one of those rights. We would proceed directly to sanction, and there's no appeal for that. You can't say it's not fair, or you were treated badly, or anybody violated your rights after that. You're waiving everything. Do you understand all that?
Yes.
All right, let me look up here. Do you want to admit to the violation today? Or you want to have the state prove the case against you? It's entirely your call and has to be your call.
I mean, Yeah.
Okay. So has anyone forced, threatened, or coerced you or offered you anything of value to get you to admit to the violation today?
No.
Raise your right hand. For solemnly swear or affirm under the penalty of perjury the testimony you're about to give is truth.
Yes.
Thank you, ma'am. And can you give me a factual basis for the violation, please?
Okay, Amanda, if you could please state your name.
Amanda White.
Okay, and you're saying Amanda White, that is the defendant in this matter? No.
Yes.
Okay,
Yes.
okay, so yeah,
Sorry.
say yes or no, all right.
Yes.
All right, you were placed on community corrections, I believe, back in October of 2025. Pursuant to a probation violation that you had, is that correct?
Yes.
All right, and there were terms and conditions of that community corrections?
Yes.
All right, one of those was that you abstained from using illegal substances, yes. Now, there was, I think on 2 occasions, one was filed in November of 2025, and then another in August of 2024, in August of 2025, so. Did you test positive for methamphetamine? Those days?
Yes, I did.
Okay, is that a violation of your community correction?
Yes, it was.
No other questions, John?
All right, thank you, ma'am. Ms. White, do you now admit then that you violated the terms of your community correction placement?
Yes.
Thank you. I find that you did violate the terms and conditions of your placement. Your admission was freely and voluntarily given. There's a factual basis to accept it. Ms. McCray, what is your official recommendation today, please?
Your Honor, given that this is the 3rd petition to revoke on Ms. White and amended no less, I'm going to be requesting a full revocation on behalf of the state.
All right, thank you, ma'am. And officially your recommendation today?
I agree with the revoking all of it, but would like her to go back on community corrections.
All right, thank you, ma'am.
With the condition of being in sober living.
Yeah. And no, to give me 1 second, you're going to take her with you too, please. I can't do that today. We've had a lot of time. This has been pending. We've had multiple violations, including bonds. So what I'm going to do today, Ms. White, is revoke those balance of 350 days you had over your head. Actually, it's 312 days. Revoke the 312 days you had and terminate your placement as unsuccessful. You're going to serve that in the Clark County Jail. That's it for the day. All right.
All right.
So they're gonna come, you're gonna go with the officer here, and you're done with this case entirely. And you'll be released in what 100 or 300, you'll be released 156 days. So when you get out, you're done. You don't have any responsibility here. I don't know what happened with the other case from 2023 though. So make sure you're following up on that if there's a case. All right, that is it for today. Thank you, ma'am. Give me 1 second. I'll give you this one too.
All right, guys. We made it to the end. She didn't like what happened there, but it happened. That's what happens. I showed you a couple judges that just don't take any crap tonight. Oh. And then I showed you the most epic lawyer from Kentucky. If you're here for court videos, it's over. There's no more court videos I'm going to play tonight. I have some, but they're for the morning because we have a stream in a couple hours, guys. And I was supposed to end this like 30 minutes ago and use some of that for tomorrow. So now I have to scramble. I couldn't help it. I didn't want to stop. I did not. I really appreciate you coming out. I really appreciate you guys finally getting Bobby. I really appreciate you just showing up and chatting. I really do. Thank you. I'll see you again in a few hours. All right, guys, go get some sleep. Listen, if you're here for this stream, just go sleep. You don't have to show up to every stream. This is not a job. You're supposed to relax and enjoy your life. So make sure you don't think of it as a job, okay? I'll see you next time, though. Bye, guys. Behave. Well, I thought I'd write a happy song. Come on, guys, sing.
I found a chat room where I belong. You don't know how much it means to me with such a groove. she's got that grace, come join the fun. It's a welcoming place. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in